I'm a living, breathing person, human being. For example, McDonald's. McDonald's can't force me to eat their Big Macs. They need my consent. I would like to state for the record that I am not a corporation. I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort.
Today's case features one of the most bizarre arguments we've seen from a so-called sovereign citizen. This man appears before the Court of Appeals attempting to dodge his child support obligations. You'd think he came prepared with sound legal defense. But instead, what unfolds is a masterclass in confusion. He challenges basic law, questions authority, and treats the whole hearing like a debate club. The result? A courtroom full of disbelief. You really have to hear his reasoning to believe it.
If you wouldn't mind putting your name on the record, please.
I'm the executor and sole beneficiary of the trust and estate of Mr. Kevin Dwayne Craft, the legal persona. I am not here making a general appearance. I'm here by special divine appearance, judge, to settle a matter, to call for a constitutional court of record to ask for a summary judgment upon the truth and facts that I placed upon the record with my documents. I stand firmly on my rights, and I'm here to ask for that summary judgment, please.
You've asked for.
I do also have a few questions.
I understand you're pro se, and then therefore you get a little bit of leeway, but typically the judges don't answer questions. We're the ones who ask questions. This isn't like a trial court where it's a very kind of back and forth. The Court of Appeals is more structured in terms of the lawyers or parties come up, they make their arguments. The judges may or may not have questions for the person, and then it's submitted, and then we go back and discuss the matter, and then at some point in the future we come out with an opinion. So it is different in that respect than trial court.
Understood. But I am wondering if this is a court of constitution, and would the Constitution be applied in these proceedings?
The Court of Appeals, the Michigan Court of Appeals, is provided for under the state Constitution of 1963.
Is that a yes?
That's the answer I'm giving you.
Okay. I'm asking to verify to make sure these proceedings are legitimate. The Constitution has two jurisdictions: common law, admiralty law, or maritime tribunal. And I'm asking in which context would this court try to enforce jurisdiction on me?
We're acting under the state Constitution of Michigan of 1963.
Moving forward, I'm here to pretty much address the court's error for ignoring my motions. Notice of dismissal, default judgment under Federal Rule 55 was filed December 12, 2022. Under Federal Rule 55, if a party fails to respond to the defendants themselves, and this is confirmed by my affidavits, and other means, the clerk must officially record a default judgment of that party. I filed several motions and they were ignored. That's why I'm here. In Haynes versus Kennar, 404 U.S. 519, 1972, courts must be understanding and not easily reject motions from people just representing themselves. And that's what took place in this matter. In Article 1, Section 17 of the Michigan Constitution prevents courts from ignoring motions and guarantees that people have a fair chance to represent themselves in any argument and evidence. That did not happen. That's why we're here. The state ordered me to take a paternity test. And Monell versus Department of Social Services, which is a New York State case. The Supreme Court case established that municipalities' liability under the Section 1983 for constitutional violations in the context of child support cases, where the appellant argues that a warrant should be required for me obtaining genetic and biological material. I think it's very sensitive when a state injects an order asking me to give genetic and biological material without a warrant.
From the start, it's clear this man isn't here to take responsibility. Every word he says sounds like a desperate reach to avoid paying child support. What's even stranger is his outrage that the court wants biological proof the child is his. He calls it a violation of his rights, when in reality, it's just standard procedure. The state isn't conspiring against him. It's following established science and law. The whole situation feels less like a legal argument and more like an attempt to escape accountability. And honestly, it's hard not to feel bad for the child caught in the middle of the circus.
That's really sensitive material. It's not like a document or anything. That's personal biological material. That's why those specimens were not granted. That's why I deny any consent or any contract with the state or Title 4D agency to give away my biological and genetic material. That the case Monell is relevant because it underscores the importance to ensure that government agencies like the friend of the court on this context. These are for-profit agencies disguised as government agencies like the friend of the court, adhere to constitutional standards where collecting evidence potentially implying the need of procedure safeguards to protect individuals' Fourth Amendment. That's why I asked, with this a constitutional court. The asking for genetic material is protected by my Fourth Amendment right. The Fourth Amendment protects individuals from unreasonable searches and seizures and safeguards one's privacy and assurance that any such search is conducted within the boundaries of legal requirements. I see that they're not here today, and that's some questions that are raised, and those were my concerns. On August 11, 2022, the Kent County ordered an appointment for me for genetic and biological testing. In a testing laboratory, DNA Diagnostic Center is a business, and I can prove it's a business because I have their Dun and Bradstreet numbers, 877-184226 for the record. They also said, when I thought this was funny, the state of Michigan stated that it would pay the cost of the genetic test, and if I wasn't excluded, that I would be responsible for that cost. And with that being said, that set alarms. The state of Michigan is also a business. And with them fronting the cost for me, that presented an alarm for me because I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort for them to upfront the cost if I was going to be responsible. I do not consent to that business arrangement. The state, they failed to show a promissory note of a contract of any sort. I submitted documents, notice to the court to demand dismissal for lack of jurisdiction, demanded to see an open court evidence of personal and subject matter jurisdiction, and notice of court to refusing to appear voluntary. And I do not accept the offer to contract, and I do not consent to these proceedings. That affidavit or notice to motion was submitted on November 28th, 2022. So again, I'm just bringing up the point that I submitted numerous of documents asking for clear evidence or asking for due process, also asking for just quite frankly, to be transparent with what's happening. And I believe I deserve the right to see in writing what gives them the authority and what contract am I entering. I want full disclosure.
Then comes his main argument. He demands to see the contract that supposedly gives the state authority to collect his biological data, but there is no secret contract. Family courts have the right to request DNA testing when paternity is in question. That authority is rooted in law, not paperwork hidden behind closed doors. The purpose is simple: to ensure the correct parent supports the child. This isn't a trap. It's a protection for both the parent and the child. Yet somehow, he treats the entire process like it's an attack on his freedom. It's hard to imagine the appellate court doing anything other than dismissing his claims outright.
Burns 322 BR 719, a creditor must provide proper documentation such as a promissory note, contract to substantiate a debt or court claim. They did not. More documents I filed. Affidavit inserting corporate nature of government entities. I submitted that document because I'm concerned that these are for-profit businesses disguised as government agencies. You know, I have proof. Kent County Court, Dun and Bradstreet number for the record, 152906082. Kent County Friend of the Court, Dun and Bradstreet number, 6088333133. State of Michigan, Dun and Bradstreet number, 504698428. These are businesses. I would like to state for the record that I am not a corporation. I'm a living, breathing person, human being.
And here's where it gets even stranger. He starts repeating one of classic sovereign citizen lines, claiming he's a living, breathing human being and therefore not subject to the law. It's the kind of phrase they believe will magically erase legal responsibility, as if the court will suddenly say, "Oh, you're human? Never mind, the law doesn't apply." These arguments never hold up, yet they continue to spread online like wildfire. Where these people pick up such ideas remains a mystery. But one thing's certain, real-world courts don't operate on internet slogans.
They have to abide by the same rules as other businesses. And may I give an example? For example, McDonald's. McDonald's can't force me to eat their Big Macs. They need my consent. None of these businesses that I've mentioned have my consent to do business with them. Section 458 of the Social Security Act, incentive payments to state. It's a conflict of interest. And it's my argument right here, right now, that the state incentivizes them it incentivizes them to collect more child support. The main argument I have here and for you guys is full disclosure. You know, it seems like they enter me in a contract without my consent, without full disclosure, and that's the problem here. You know, I'm here to argue subject matter and lack of jurisdiction. No evidence was established in my involvement of a common law crime or damages, and I did not commit any common law crime. Notice of court to refusing to appear voluntary, and I do not accept these contracts, and I do not consent to these proceedings was another motion or notice to motion that I submitted 11/28/22. And it's basically it's evidence they didn't provide any evidence of an injury or injured party. And
Mr. Kraft, you're out of time. We understand that you raise issues of disclosure,
yes,
jurisdiction, remedy, and as I indicated, your brief, as with all the appellants and appellees we have here today, the briefs that you submit are kind of the key issue or the key tool that we use to resolve cases. And so I just want you to know, we have your brief.
Mm-hmm.
We're going to go back. We've had research attorneys look at it. We're going to look at it again. We're going to discuss your case. And then you'll get an opinion from us sometime within the next few weeks.
If I may, one last thing.
You've got, if you can do it in 20 seconds.
I can. The government must prove charges beyond a reasonable doubt with clear evidence, especially when making the claims against someone. And I'm asking you guys right here, right now, they did not provide any evidence against me. And I will ask you to dismiss this without prejudice.
Finally, he closes with a plea for the court not to hold prejudice against him, almost as if that single line will make the judge overlook everything else. It's an odd mix of confidence and confusion, and you can't help but wonder who convinced him this would work. His defense about the state lacking authority to order DNA testing isn't the most absurd thing ever heard in court, but it's nowhere near convincing. If he had legal counsel guiding him, perhaps things wouldn't have spiraled into this spectacle. Instead, every word he says digs a hole deeper. In the end, this isn't about freedom. It's about accountability. Try it out, argue the law never works. And this case proves it once again.